Mackenzie Shirilla has been hit with another legal blow, and this one might be the one that closes the door on her freedom for good. The Ohio Supreme Court has officially refused to hear her appeal of her murder convictions, and what that means in plain language is that every argument she has made, every legal maneuver her attorneys have tried, every claim that she was wrongfully convicted or that she had bad lawyers or that some medical condition caused all of this, all of it has now run straight into a wall, a legal wall. And unlike the wall her car ran into back on July 31st, 2022, this wall is not going to give way, and it is not going to result in any appeals because she just lost her appeal. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. And look, before we get into all of this, I want to make sure you are set up the right way if you are someone who creates content. If you put things out online, if you run a YouTube channel or post clips anywhere at all, you need to know about Opus Clip. Opus Clip is an all-in-one AI video editor that takes long-form content and turns it into short, viral, perfectly formatted clips for TikTok, for YouTube Shorts, for Instagram Reels, all of it. It uses artificial intelligence to reframe footage, generate B-roll, clean up audio, add captions, do basically everything you would spend hours doing manually. You just go to Opus, Pro Sidebar, you sign up, you upload your content, and within minutes, you are looking at a library of edited clips ready to share. Our own producers here at Sidebar use it to get you courtroom updates and legal breakdowns out across platforms as fast as possible. That is how you're seeing these clips on your feed so quickly. The tool is that powerful. Go to Opus, Pro Doc Sidebar, and you get a free week and then 50% off after that. Seriously, check it out. Okay, now let's talk about Mackenzie Shirilla, because there is a lot to unpack here, and I want to make sure you understand exactly what happened, why it happened, what the court said, what it didn't say, and what it all means going forward for a young woman who may now have no legal options left, at least not for a very long time. So let's start from the beginning, because some of you watching this may be coming to this story fresh, and some of you have been following every single development since the very beginning. Either way, I want to give you the full picture before we get into the legal weeds here, because the context matters enormously. Mackenzie Shirilla was 17 years old on the night that changed everything. She was driving a car in the early morning hours of July 31st, 2022 in Strongsville, Ohio. In that car with her were two people. One was her boyfriend, a young man named Dominic Russo. The other was Dominic's friend, a young man named DaVon Flanigan. Both of them were passengers. Both of them were killed. The car, and this is where the facts start to get really damaging for Shirilla's position, the car was traveling at more than 95 miles per hour in a 35 mile per hour zone. The vehicle's event data recorder, sometimes called a black box, the same kind of technology used in aircraft accidents to reconstruct what happened. That data recorder captured everything. The accelerator pedal was 100% depressed. Not partially, 100%. And at no point during that final stretch of road, during those final seconds before impact, did anyone apply the brakes. The car held its lane through a curved section of road without veering off, which the prosecution would later use to argue that Shirilla was in conscious, deliberate control of the vehicle. And then the car hit a building. Dominic Russo and DaVon Flanigan both died. Mackenzie Shirilla survived. Now, I want to be very careful here, because in a case like this, there are competing narratives and competing evidence, and I want to walk you through both of them, because that is the only fair way to cover this. The prosecution's narrative is about intentional murder. They argued from the very beginning that Shirilla drove that car into that building on purpose. They pointed to evidence that she had made a threat before, that she had threatened to crash her vehicle while Dominic was inside it. That is an enormous piece of evidence. When you combine that prior threat with the data recorder evidence showing full acceleration and no braking and controlled steering through a curve, the prosecution's theory starts to look very compelling. This is also not a jury that decided the case. Shirilla's defense team made the strategic decision to waive a jury trial and instead opt for what is called a bench trial, meaning the case was decided by a judge and that judge found her guilty. And I mean really guilty. 4 counts of murder, 4 counts of felonious assault, 2 counts of aggravated vehicular homicide, 1 count of drug possession, 1 count of possessing criminal tools. The judge in this case was not lenient, and when you read through the findings, you can understand why. The evidence was stacked. The defense narrative, on the other hand, centers around a medical condition. Shirilla and her family have maintained from the very start that she has no memory of the crash, no memory of the moments leading up to it. She says she blacked out. And the explanation they have offered for why she blacked out is a condition called POTS, which stands for Postural Orthostatic Tachycardia Syndrome. Now, POTS is a real medical condition. It is not something fabricated. It is a syndrome that affects the autonomic nervous system, and one of the things it can do is cause a dramatic drop in blood pressure when a person stands up or changes position, and that drop in blood pressure can lead to dizziness, and in more severe cases, it can lead to loss of consciousness. Shirilla's family says she was diagnosed with POTS back in 2017 at the Cleveland Clinic. Her mother, Natalie, testified at trial. She described having witnessed her daughter experience episodes related to the condition. She described one incident where Shirilla collapsed to the kitchen floor. She described a particularly bad episode that occurred just 1 to 2 weeks before the crash. She said it was really bad, and it scared her. And here's the part that becomes critically important, and honestly, somewhat damaging to the defense position. Despite knowing about this diagnosis, despite witnessing these episodes, Natalie helped Shirilla apply for a driver's license twice after the POTS diagnosis was made. Neither time did they disclose the condition to the licensing authority. And Natalie admitted on cross-examination that after that bad episode, 1 to 2 weeks before the crash, she did not take Shirilla to a doctor. She did not limit Shirilla's driving privileges. She did nothing to prevent Shirilla from getting behind the wheel. Now, at the trial itself, there was no formal medical diagnosis introduced through expert testimony. No expert witness took the stand and said definitively that Shirilla had POTS, that it caused her to lose consciousness, that this is what happened. The defense did not secure that kind of testimony. Shirilla's mother testified about what she understood the condition to be. A doctor in the case, Dr. Sang, testified, and on cross-examination, Dr. Sang admitted that a blood oxygen level of 82 would be abnormally low for most people. Dr. Sang also admitted that someone with POTS could experience dizziness or a headache. And the court noted that medical personnel evaluated Shirilla approximately 2 hours after the crash and acknowledged that someone who had suffered a seizure or a mini-stroke could potentially have recovered within a 2-hour window. So there was at least some acknowledgement that the medical defense was not entirely impossible. But then you get to the part that the court found dispositive, the part that really seemed to sink the POTS argument, and it comes down to one specific piece of evidence that the defense never had a satisfying answer for. Someone manually moved the gear shift back into drive after it had been shifted into neutral in the seconds before the crash. Think about what that means. The prosecution is saying that the vehicle data shows a deliberate manipulation of the gear shift, a conscious act. And there was no evidence presented, none at all, that any medical condition, any blackout, any POTS episode could simultaneously cause someone to lose the ability to brake or lift their foot off the accelerator while also causing them to intentionally, deliberately, manually shift the gear. That is the logical gap the defense could not close. And it is the gap that the court pointed to when it returned those guilty verdicts. She was sentenced to 2 concurrent terms of 15 years to life in prison. And because of all of this, because of those sentences, because of her age, because of the facts of the case, and because the case ended up on Netflix in a documentary called The Crash, Shirilla became one of the most talked about defendants in recent memory. People have very, very strong opinions about this case. Some people believe she intentionally killed those young men. Some people believe this was a terrible accident caused by a medical condition that was never properly explored at trial. And it is the second camp, the people who believe she was wrongly convicted, or at least that she deserved a better trial, who have been watching the legal proceedings that followed her conviction very closely. And those proceedings have not gone well for her. Not at the Court of Appeals level. Not at the Ohio Supreme Court level. And now, so once again, the Ohio Supreme Court has said no. Let me be very specific about what happened here, because the Ohio Supreme Court's refusal to hear this case is not, strictly speaking, a ruling on the merits of her arguments. It is not the court sitting down, reading everything, and then saying, we considered all of this and we rule against you. That is not exactly what happened. What happened instead is that the court issued a very brief order. It was signed by Chief Justice Sharon Kennedy, and the order simply states, and I'm going to read the relevant language here, that upon consideration of the jurisdictional memoranda filed in this case, the court declines to accept jurisdiction of the appeal pursuant to Rule 7-084. That is it. That is the entire substantive content of the order. One sentence. A reference to a procedural rule, no written opinion, no analysis of her arguments, no engagement with the facts, no statement about whether she was right or wrong, just a decline. And I looked into Rule 7-084 of the Ohio Rules of Practice, and what it tells you is that the Ohio Supreme Court has 3 basic options when it receives an appeal like this. It can accept the case and order full briefing on the issues. It can enter judgment on the matter immediately, or it can decline to accept jurisdiction altogether. And when you look at the types of cases the Ohio Supreme Court typically agrees to hear in the criminal context, the standard is that it has to be a case of public or great general interest, or it has to involve a significant constitutional question under either the Ohio Constitution or the United States Constitution. The court did not say which of those standards Shirilla's case failed to meet. It just said no, which leaves us to read between the lines, and I'll tell you what I think we can reasonably infer. But first, let me explain what Shirilla was actually arguing in front of the Supreme Court, because that is essential context. Now, this post-conviction petition, this is very important to understand because it is different from a standard direct appeal. In a direct appeal, you are typically looking at the record of the trial itself. You are saying the judge made an error, the jury was given bad instructions, the evidence was improperly admitted, something like that. A post-conviction relief petition is a different animal. It allows a defendant to raise constitutional claims that go beyond what is in the trial record. It allows a defendant to introduce new evidence. It allows a defendant to say that their constitutional rights were violated in ways that may not even be visible from the trial transcript alone. And the specific constitutional claim Shirilla was making in this petition is what lawyers call ineffective assistance of counsel. It is a Sixth Amendment claim. The Sixth Amendment to the United States Constitution guarantees the right to effective assistance of counsel in criminal cases. And Shirilla's argument, in essence, is that her trial lawyers failed her, that they knew about her POTS diagnosis, they knew about her medical history, and they did not adequately investigate it. They did not bring in experts. They did not present the kind of medical evidence that could have given the fact finder a real basis to consider the possibility that she blacked out. They dropped the ball. And because they dropped the ball, she was convicted of murder when she might have been acquitted. That is a very serious claim. That is exactly the kind of claim post-conviction relief petitions are designed to address. But here's where things get procedural, and this is where the whole thing starts to fall apart for Shirilla. And it is genuinely painful to read when you understand the stakes. In Ohio, there's a statute that governs when you can file a post-conviction relief petition. Under that statute, you have a window of 365 days from the date the trial transcript is filed in the direct appeal. 365 days. You have to file within that window, or your petition is considered untimely, and it will be rejected. And what happened in Shirilla's case is that she missed that window. But she argues, and this is the core legal question she brought to the Ohio Supreme Court, that she did not actually miss the window. She argues that the lower courts calculated the deadline incorrectly. And the reason she says that comes down to a definitional question. What exactly is a trial transcript? Because that is the document that starts the clock running. And she says the answer to that question is less clear than the trial court and the Court of Appeals assumed it to be. Here is the timeline as I understand it from reviewing the filings. Shirilla filed a notice of appeal of her conviction in September of 2023. Her attorney requested all of the relevant court records, the main trial court records, the transcript of the actual trial. Those were filed on October 24th, 2023. That date is critical. But there was another hearing that was part of her case, a hearing that took place in juvenile court, a probable cause hearing, and the transcript of that hearing was not included with the main trial records. It had to be tracked down separately, and it was not filed until December 15th, 2023. So now you have two dates, October 24th, 2023, when the main trial transcripts were filed, and December 15th, 2023, when the juvenile court transcript was finally filed. Shirilla's new attorneys, the ones handling the post-conviction work, filed her petition on October 24th, 2024. And here is the brutal math. If the clock started running on October 24th, 2023, and she had 365 days, then her deadline was October 23rd, 2024. Because 2024 was a leap year, 365 days from October 24th, 2023 lands on October 23rd, 2024. She filed on October 24th, 2024, one day late. If the clock started running on December 15th, 2023 instead, the day the juvenile court transcript was filed, then she was well within the window. She was on time. The entire case hinges on that one question. Which document starts the clock? Shirilla's brief before the Ohio Supreme Court argued that the term trial transcript is ambiguous. She went through various court decisions that have grappled with how to define trial transcript in different contexts. Her key argument was essentially this: what is a trial transcript supposed to accomplish, functionally, in the context of a post-conviction petition? It is supposed to give the defendant's post-conviction counsel a full picture of what happened in the proceedings below. You cannot evaluate whether a lawyer was ineffective unless you have reviewed the entire record. Not just the jury trial, if there was one, but all the proceedings that contributed to the conviction. And she argued that, in her particular case, the juvenile court probable cause hearing was not some minor, irrelevant sidebar. It was a genuinely significant part of the proceedings. Her post-conviction counsel needed to review it, and the fact that it arrived late should mean the clock started late. She cited due process arguments. She cited the 14th Amendment. She argued that basic constitutional fairness demanded that her petition not be thrown out because of one day that resulted from ambiguity in the law and the late arrival of a transcript that she needed and that her attorneys had to wait for. The state's response was straightforward and, I will be honest with you, pretty effective. The prosecution said, look, trial transcript means what it says. A trial is a trial. A juvenile probable cause hearing is not a trial. It is a pretrial proceeding. It is not the proceeding in which guilt or innocence was determined. The main trial transcripts were filed October 23rd, 2023. By the way, the state actually pegs the date as October 23rd, not October 24th, which makes the math even worse for Shirilla. If it was October 23rd, 2023, and the deadline was 365 days later accounting for the leap year, then she filed 2 days late, not one. Either way, late is late. And the state cited a prior decision from the 8th District Court of Appeals that drew a clear distinction between Shirilla's case and another case where the court had been more flexible about the definition of trial transcript. In that other case, a case involving a defendant who had pleaded guilty, there was no trial in the traditional sense, so the court had to be creative about what transcript started the clock. That is not Shirilla's situation. Shirilla had a trial. There is a trial transcript. The clock started when that transcript was filed. End of story. And the prosecution also went after Shirilla's constitutional arguments, saying those claims were forfeited because they were not raised at the proper time in the proper way. And they pushed back on the argument that granting this petition would have led to an acquittal, saying Shirilla's brief fails to actually engage with the trial evidence and explain why it would have led to a different outcome. Now, those were the competing arguments. The Ohio Supreme Court considered the jurisdictional memoranda, which is essentially the streamlined version of these briefs submitted at this stage of the process, and it said no, declined to accept jurisdiction, gave no further explanation. And this is, I want to note, the second time the Ohio Supreme Court has refused to hear something related to this case. The first time was a more standard direct appeal of her conviction. Shirilla had argued at that stage that the prosecution had failed to prove the element of intent beyond a reasonable doubt. The 8th District Court of Appeals upheld her conviction. She went to the Supreme Court. The Supreme Court declined. That was a different issue from what we are talking about now, but the pattern is the same. Every level of the Ohio courts has rejected her. Every single one. Trial court. Court of Appeals. Supreme Court. Trial court again on the post-conviction petition. Court of Appeals again. Supreme Court again. And look, I want to be honest with you about something, because I think about this case a lot. If you just read the brief that Shirilla's lawyers filed, stripped of all the procedural arguments about when the clock started, there's a real human story underneath it. The opening paragraph of her brief is striking. It says this is a 17-year-old girl who is now serving a life sentence. It says there was medical evidence that could have been developed, that should have been developed, that was not developed because defense counsel did not do the work. And it says that because of that failure, she could die in prison without having had a fair shot at presenting her best defense. That is a powerful argument. It is the kind of argument that makes you sit up and pay attention, even if you believe she is guilty, even if you think the evidence against her is overwhelming, because the system is supposed to work in a certain way. Defense lawyers are supposed to investigate. Defense lawyers are supposed to bring in experts when they are available and relevant. The Sixth Amendment means something. And I'm not saying her lawyers were ineffective. I am not a judge. I am not making that determination. But I am saying that the argument she is making is not a frivolous argument. It is the kind of argument that, if she had filed on time, the courts might have actually engaged with on the merits. Instead, because of one day, they never had to. The flip side of that, and I want to be fair here, is the prosecution's position, which is that the rules exist for a reason. Deadlines exist for a reason. The legal system cannot function if every defendant who misses a deadline by a day gets an exception. And especially in a case like this, where the prosecution makes a compelling point that Shirilla herself, in her own filings, referred to the main trial transcripts as the trial transcripts, distinguishing them from the juvenile court proceedings. If her own attorneys are calling the main transcripts the trial transcripts, it is hard to then turn around and say the definition is ambiguous. That is a real problem. That is the prosecution pointing to something and saying, look, your own words undercut your argument. And the Court of Appeals, the 8th District, found that argument persuasive. It found unanimously that the statutory phrase trial transcript refers to the record of the adjudicatory proceeding in which guilt was determined, and that a juvenile probable cause hearing is not a trial. And therefore the clock started in October of 2023, and therefore she was late. So what does all of this mean for where things stand right now? Let me give you the honest picture. As far as anyone can tell, and this is based on reviewing the available legal filings and public reporting on the case, Shirilla has essentially run out of options in the Ohio state courts for right now. The Ohio Supreme Court has declined to hear this case twice. The courts below have rejected her on the post-conviction petition. Her direct appeal of the conviction has been exhausted. She is serving 2 concurrent sentences of 15 years to life. What does that mean in practice? It means she will not be eligible for parole consideration until 2037, which is when she will have served the minimum 15 years of her sentence. And whether she gets parole at that point is an entirely different question. Parole boards consider a lot of factors. They consider behavior in prison. They consider whether the person has taken responsibility for the crime. They consider victim impact. And I will say this carefully because it is a real consideration. The way Shirilla has conducted herself since her conviction, including a lengthy on-camera interview in the Netflix documentary The Crash, in which she maintained her innocence, insisted there was no intent, and described the situation in ways that some found inappropriate, given the gravity of what happened to Dominic Russo and DaVon Flanigan. Those things are going to be part of the conversation when the parole board eventually considers her case. I'm not saying that makes her ineligible. I am saying it will be a factor. Whether it is a decisive factor, we will not know for more than a decade. Now, is there any path forward at all? I want to be careful not to close every door because the law is not always as simple as it looks. There are a couple of theoretical avenues. One is federal habeas corpus. That is a petition filed in federal court, and it is a very specific and very narrow vehicle. It is not a way of relitigating the whole case in federal court. It is a way of arguing that your federal constitutional rights were violated and that the state courts failed to correct the violation. The standards are high. The deference given to the state courts is enormous. Federal habeas corpus is not a magic button, but it exists. And if Shirilla's attorneys believe there are federal constitutional claims that were not properly adjudicated in the Ohio courts, they could potentially pursue that route. The other theoretical avenue is newly discovered evidence. If something comes to light, something genuinely new, something that was not available at the time of trial, and that is material and exculpatory, there are mechanisms to bring that forward. But that is speculative. We do not have any indication that such evidence exists. And the Potts argument, as compelling as it may be emotionally and even medically, has been in the picture from the very beginning. It is not newly discovered evidence. I want to close with something that I think is worth sitting with. In that Netflix documentary, Shirilla gave her own account. She said, "I am big on the no intent. There was no intent whatsoever there. I have excessive amounts of remorse for Dominic, DaVon, both of their families. This was not intentional, and I will do everything I can to prove that to the world and the families." And I think whether you believe her or not, whether you think she drove that car into that building on purpose, or whether you think she blacked out, there is something profound about the fact that 2 young men are dead, that their families are living with that loss every single day, and that the legal proceedings surrounding those deaths have now spanned years and produced nothing but conflict and pain. And now the Ohio Supreme Court has, for the second time, walked away from this case. Has said, not our issue, not our problem, decline. And Mackenzie Shirilla is left to sit in a prison cell and think about 2037 and wonder whether 15 years will be enough. From where I sit, having read the filings, having followed this case, I do not think this ruling is surprising. I think the 8th District's analysis was solid. I think the prosecution's argument about what trial transcript means is textually persuasive. I think the law in Ohio is clear enough that the Supreme Court did not feel the need to step in. And I think the deeper tragedy here is that if Shirilla's post-conviction petition had been filed on time, if her lawyers had calculated the deadline correctly, the courts might have at least been required to look at whether the Potts evidence was inadequately developed, whether there really was a Sixth Amendment violation, whether she deserved a new hearing. Instead, because of one day, we will never know. The courts never had to look at it on the merits. And that is the part of this story that I think will haunt the people who believe in her innocence for a very, very long time. One day. One single day. That is all we have for you here on Sidebar. Thank you, as always, for watching, for subscribing, for being part of this community. If you want to follow me personally, you can find me on X and Instagram, and you can catch me on my News Nation show, Jesse Weber Live, Monday through Friday at 11 p.m. Eastern. Please subscribe on YouTube, Apple Podcasts, Spotify, or wherever you get your podcasts. You can also check us out on NBC's Peacock. We will see you next time, everybody.